Good morning, good afternoon, wherever you are in the world. And just to make sure you're clear on this, yes, I do know I'm late, nearly 20 minutes late, which is unusual for me. But I've got a few things going on in the background, some strange occurrences happening. But we're going to talk through something. First thing I'm going to say to everyone, I'm so grateful for all the support I'm getting from people. Even if it's just offers of moral support, etc. The other side, I think I just heard something go ting then. I don't know what that was. So majorly, I just want to make sure everyone gets this. Let's have a look. Make sure you're all up there. Good day all. Let's have a look and see anyone's out there. Don't forget, caring is sharing. Don't forget to subscribe, and don't forget to like. Really important on all platforms. You're the only people getting this message out there. More and more people talk about the Constitution. And again, what we don't want are any of these British barristers talking absolute nonsense who have been indoctrinated by the British to tell people that we haven't got a constitution or that Parliament is sovereign, right? The Constitution is sovereign. And I'm going to go through a few things tonight with you. But before I do, and that means this is shared sovereignty, I do want to make sure you all see this image on your screen. That is going to look a bit weird, but we'll bring it up. Hopefully you can see it. I think you can see it on your screen. Tell me if you can see that coming up on your screen. Let's have a look and see what's coming up. There it is. Not sure if I've put the wrong thing up. I think I have. Let me see if I can do it again. William Pitt. Let's see if that's the one. I think. Yeah, that's it. That's the one I'm looking for. So, William Pitt, first Earl of Chatham, 1708. And by the way, you can go and see this on literally on everyright.org. William Pitt, first Earl of Chatham, 1708 to 1778. Instead of the arbitrary power of a king, we must submit to the arbitrary power of the House of Commons. If this be true, what benefit do we derive from the exchange? Tyranny, my lords, is detestable in every shape, but none so formidable as where it is assumed and exercised by a number of tyrants. But, my lords, this is not the fact. This is not the Constitution. We have a law of Parliament. We have a statute book and the Bill of Rights. Right, so just to make sure everyone's aware of that. Again, you can pick that up. That actually comes from Hansard. Right, so Hansard itself, the parliamentary record, recognises that Parliament is not sovereign. We have a constitution, we have a Bill of Rights, and they are limited in the laws that they can make. And the monarch is limited in what they can assent to or dissent from, and the arbitrators of any disputes from Parliament, the monarch, or the people are the independent judiciary, as stated by the late Her Majesty Queen Elizabeth II, July 20th, 1988, in a declaration, not just a speech, a declaration to both Houses of Parliament. A declaration is a very important legal definition. A declaration is you're telling people what the law is. And when Her Majesty the Queen made that declaration to both Houses of Parliament, it was reasserting the English Bill of Rights. And again, our friends from America came here and they were invited not only to attend Parliament, but also, I believe, came with her to Brixham, where the Prince of Orange landed on the 5th of November, 1688. And he come from all the way through Devon with his forces. 3,000 of those forces were English men and some Scots, because don't forget, the Scots were also Protestant, or many of the Scots were Protestant, and they come over not to invade, but to what's the word I'm looking for? Liberate the English from the rule of Jesuits, right? So all of this is basically in these books, but there is something I want to show you, and I'm hoping I'm going to go straight to it. There's a particular part of this. Let me have a look. Very important. There it is. Right. So there's a particular part of this which I'm going to show you now. If you don't mind, I'll have a little sip of coffee while I'm at it, because I don't want. It's very distressing when Janet keeps making me cold coffee. And currently it's not cold. Right, so what I want to do is make sure you all get this completely. So I'm hoping I'm going to be able to share this. It might go down on us because I'm using a high definition camera, not the laptop camera. I'm using another camera, which I'm about to show you. And hopefully we'll pick this up straight away. So hopefully you can see all this in front of you as we speak at the moment. I'm about to bring this over to you and I will tell you exactly what it is. And hopefully we can zoom in. Is there a zoom function on this? I believe there is. I'm not sure if that's a zoom function or whether that's a central function or not. Hopefully I'm going to bring this in. Let's see if I can. Why is that showing it as upside down? Maybe if I turned it around the other way. Can you see it that way? You like that, didn't you? You like that expertise there. Just turn the camera the other way and you're there, right? So I want to show you something because I think it's important, everyone says. As you said, let's see if I can read this to you. Why do I do this and show you the actual book? And then because anyone can go and buy one of these books, right? Anyone can go and get them from the library. As I did many years ago. Wasn't the type of library most people would have used, but I still used it. So, Housby's Laws of England, Volume 8, Constitutional Law, page 550. Again, paragraph 830. Right. So what I'm going to do is hopefully show you this part. Sources of civil liberties. There has been no recent legislative attempt to codify the fundamental liberties of the citizens of this country. But two such codes, so there's two footnotes, so one, and then you move along, there's another two there. So that means there's a little footnote I want to put in. Must be regarded as of influence in the development of English law in this area. The principal civil liberties are described in the following paragraphs. It is relevant to state that I'm hoping everyone can hear and see me, because I'll have to bring my mic over so everyone can hear that. Can you all hear and see me? I'll wait for the 5 to come up because my mic was at the wrong angle. I do apologise if people couldn't hear me. It is relevant to state that these liberties in no way affect the interpretation or application of any rules of law and are as susceptible to change as other rules. That's not quite true, because that book tells you that's not true. But often the liberties are to be inferred from the absence of legislation conferring their subject matter, right? But then it says, one, detailed provision of the protection of fundamental rights has frequently been made by Parliament. However, in creating written constitution for territories attaining to the independence of generally Commonwealth, Volume 6, Paragraph 1024, reference might also be made to the Bill of Rights, 1688, Section 1. Certain of these liberties, there, and if you don't know where I'm reading from, it's here, right? I want you to understand what this says in the Houseby's Laws of England. Certain of these liberties protected by Section 1 are referred to in the succeeding paragraphs. Other liberties guaranteed by Section 1 include protection from the suspension of laws or the execution of laws without parliamentary consent, and protection from dispensing with laws or of the execution. Let me just make sure I can bring this back up. I'll bring it back up there. This is going on to the next page. So paragraph, still the same paragraph, but page 551. Let me just make sure I'll put this on there, because everyone should be able to read this, right? Laws of royal prerogative. Now, there is an important part of the royal prerogative, which I'm going to get to in a few minutes. But the right to petition the Crown, freedom of speech and debates, but freedom of speech, any of us, right? And debates in Parliament is a separate section in Parliament, and protection from grants and promises of fines and forfeitures of particular persons before conviction, right? So a forfeiture is something, I'll give you an example, what's going on with me now, right? That's a form of forfeiture. Although people like certain barristers and solicitors would disagree, if you arbitrarily stop someone from having an income that they're entitled to, that is a forfeiture for no reason whatsoever. And there's some other stuff going on at the moment, which I'll tell you about in a minute, right? Well, I might not tell you about it yet. But I do want you all to understand this part, right? Because it goes on about the human rights, 1948. It goes on various other bits and pieces. But the most important part of this that I really wanted to show you was Human Rights Convention, and then it literally goes in. Foreign relations reference may usefully be made to the first 10 amendments of the US Constitution, commonly called the Bill of Rights, much of which may be regarded as substantially constituting a codification of the relevant English law in 1791, the date of their addition to the US Constitution, right? So everyone should understand that part there is very relevant. And why is it very relevant, right? Because Jason, our American friend in the audience, has asked me on a number of occasions to cross-reference these and explain to people why it is the Constitution comes from England, right? So this is the Houseby's Laws of England. So again, what I'm going to do here is just to make sure that you can all see that, right? Which you can. Houseby's Laws of England, 4th edition. If I can't take it up any further, I'll need another little. If I had a bigger desk, which that might be coming, we'd be able to do a lot more, right? But again, I just want to make sure everyone understands what I'm talking about. So draw your attention to the Bill of Rights there, right? UN Convention. Reference may usefully be made to the first 10 use. So it's telling you reference may usefully be made to the first 10 amendments to the US Constitution, commonly called the Bill of Rights, much of which may be regarded as substantially constituting a codification of the relevant English law in 1791, the date of their addition to the US Constitution. Right? Does everyone understand that? Hopefully, I'm not sure if Jason's out there watching this, but it's a very interesting element. Is Jason out there? Jason is out there. So it's our American friend, Floridian, now living in Alaska. But he's asked me to do it. So I am going to do a full training and showing people, one, what our Constitution is, because it expressly says about codification. But this document and this book also says that the codification of our Constitution is largely codified in the English Bill of Rights. So you don't need a British Bill of Rights because we've got one. And the codification of those rights is claimed by the Scottish in the Scottish Claim of Right of 1689. Right? Does everyone understand that the English Bill of Rights is a codified constitution in effect? Right? That it says 3 times. So I'm showing you that for a reason. There's many other bits I want to show you. But it may be, I've got so many parts of this that I've gone through. There is a particular part that I wanted to have a look at. Claim of constitutional law. Let's see if that's the one that I wanted to look at. Let me have a look. It might be on this side. Appointed without sovereign license. Court of claim. There's a court of claim there. One is that, and again, I don't want to go into too much detail, but there is another way. There's many courts that exist which people don't realise still exist, right? And it's really important. Let me have a look. Statute limitations. I've already been through this a few times, but we're going to show you this part. That one is really important. That's why I've plugged it up there. Freedom of arrest. Laws may not be suspended. So what it does, it goes through here, and it basically, this book tells you on a number of occasions that you can't go against the Magna Carta in any law that you make, and you cannot. And this is Parliament, right? And it tells you yet again that there is. It says, see the Bill of Rights. Generally, as the juries, they're not allowed to take that off you, right? What they don't like is people like me going around the country now telling you about this and explaining it to you in layman's terms, because I explain this from the point of view of the subject of the realm, not of someone who is controlled. So for example, if I was a solicitor or a barrister, right? Let's just say I was a solicitor or barrister. And they said, well, you could continue with this if you like, but we're going to make a complaint about you and possibly get you struck off as a barrister. There's certainly ways in which they can easily do that. So what does the barrister or the solicitor do? They shut up, right? They won't do certain things. Recently, something happened like that, which I'm not going to go into tonight, but people need to understand it. So you've got freedom of arrest there. Freedom of arrest, any powers to commit to prison or to issue warrants of arrest or search warrants, which may have been exercised at common law by the sovereign in person or by the Privy Council members or the Privy Council or the Secretary of State, whether on their own, whether their or his own authority or on the special direction of the sovereign, has been abolished, right? Laws may not be suspended, right? So what I'm saying is, it goes through in this book and it tells you about the standing army, it tells you about Parliament, it tells you about elections. So the Crown may not interfere with the election of members of Parliament, which ought to be free, one, nor impeach or question the freedom of speech and debates or proceedings in Parliament, which ought not be impeached or questioned in any court or place out of Parliament, right? So then it says Bill of Rights, and it also says Edward I Statute of Westminster the 1st, 1275. You've all heard me talk. This is all current law, by the way. Bill of Rights 1688, Section 1, as to the privileges of Parliament generally, see Parliament, right? Impeachment, foreign ascendancy, subjection to the law. And again, there's lots of bits in here, but I'm going to try and show you something. Hopefully I can find it. I think I've got go to sovereign source of justice. I've done this on amendment. So the sovereign as a source of justice, by virtue of the prerogative, the sovereign is the source and fountain of justice, and all jurisdictions is derived from her, right? Hence, a legal contemplation, the sovereign's majesty is deemed always to be present in court. And by the way, the sovereign can never die. The monarchy can never die. It can demise, but it cannot die. You are not allowed to say the monarch has died, right? Did you know that in law, you are not allowed to say the monarch has died? You can only say the monarch has demised, right? Demise means the baton is being passed to the next monarch. It's a bit like, do you know what? Well, it's not a bit like, it's a legal fiction. The monarchy itself has no soul, it is no person, and that's why it can't face any crime, because it is technically created by law, which is the same as the British Nationality Act of 1948. But just making sure everyone understands that. But I'm trying to find you a particular part of this because I wanted to show it to you. I'm not sure where I put this in there. But it is important to what we're about to talk about. Is that it? Yeah, it is. Right, so what I'm going to do now, I'm going to show you this other part in a second. Unfortunately, most of the lawyers in this country don't understand what I am about to tell you, right? So again, I'm showing you the book and I'm showing you where it says it. So again, this is Houseby's Laws of England, which means the common law, as described by the editor, who is a High Court judge, Volume 8, Constitutional Law, 4th edition, and at page 662, Constitutional Law, paragraph 1061, right? Personal prerogatives. Now, this is important for people to listen to this. The sovereign may not grant away such personal prerogatives as the lapse of a church, for that is a trust reposed in the sovereign, or the right to make denizens, right? Do you understand what I just said? So the government and parliament cannot make the only person that can create a denizen, and a denizen means a naturalized person, right? And the king or all of the migrants currently here have been given British citizenship, have been made denizens, that is, they have been naturalized, unless it was each one was in person by the crown, it is unlawful, constitutionally unlawful. So they are constitutionally unlawful denizens, right? So I'm going to make a very bold statement because it is written in front of me and it says it there, right? Or of pardoning offences, so they can't hand away any of there's lots of prerogatives they're not allowed to give away. And if they do, they technically are not, and I repeat this to everyone, they are perjuring their oaths, right? Because they're actually creating a situation where they're not doing the job. It's a bit like saying you're a CEO of the company, you walk away, you get your money, you let everyone else do everything and you don't do nothing. So then there is no guardianship, there is no guiding winds or rudder or whatever way you want to describe it, because the person guiding the ship is not doing anything, right? But they still want to hold money out of the money. And just to make sure everyone's aware of this, right, of pardoning offences, nor, Let me see if I can bring that down a bit further, because I want everyone to get what I'm saying here. This is something that some time ago, let's see if that comes back into focus, so personal prerogatives, paragraph 1061, the sovereign may not grant away such personal prerogatives as the lapse of a church, for that is a trust reposed in a sovereign, right? So I just want to make sure if one that also means, for example, it is wholly the King's responsibility to bring the Church of England and the gospel fully to the attention of the people of this country, and certainly doing anything in relation to Islam or Judaism or any other religion, Hinduism, Sikhism, etc., would be wholly wrong in terms of promoting it as a religion for the subjects of the realm, right? Or the right to make denizens, so they're not allowed to do that, or pardoning offences, nor may she grant away the jewels of the crown, which are heirlooms and as such do not pass to the executor. All right? Do you all understand that? So what I'm trying to say, this is really, I think the person's put this in because it's so important. And there's a case number in there where you can go and read about this. The Earl of Devonshire's case, 16 at Devonshire, where I am now, 1607, right? And it tells you what was going on there. So what I'm trying to say to you is this. If the monarch cannot give away the crown jewels, right, because they're not hers to give away, then she cannot give away any form of citizenship or naturalization en masse, because you would be destroying the nation, right? This is a really important part of this book, because if people only knew this and challenged what was going on by Parliament, by the government, by the agencies that are currently run by the Fabian Society, you could say this isn't allowed. You're not allowed to do that, right? So does everyone understand? Don't just nod your heads. And I know you won't do that, right? If you don't understand, tell me what you don't understand, and I'll explain it in a way that you do. But does everyone understand what I've just shown on the screen from this book? That you all understand that this is the law book of the nation. In other words, it contains all our laws, and the other set of books contains all our statutes on constitution and the charters, etc. Do you understand what I just said? Let me have a look. English law is a very fair law and full intelligence, using common sense. Right, I would say that that's pretty much common sense, right? So the common sense side of this is, if the king can't give away the crown jewels, if he can't give away the crown, he can't give away anything else either. The crown jewels, as in this nation, don't belong to him, right? And it cannot be done, right? So that also means you cannot, and it clearly states there, right? For that is a trust reposed in a sovereign, or the right to make denizens, right? So he can't give away his right to make denizens, and by giving away. And again, if you go and read, and I don't mean, can you see if you got my John Wade book there? Not sorry, William Wade book. There's another book there by Sir William Wade, which I'm about to show you. 2 seconds. Let's go back to my main screen.
What colour it is?
Let's go back to my Brio camera, where you'll see my ugly mug up there again for a while. No, it's a little red book. Tiny little red. No. You had it there. One of them. Yeah, but which one is it? That's William Wade. That's it. What? You're learning. Hey, my favourite librarian to my left. She's going to slap me when I come off this show.
Refill.
Thank you, darling. Would help if you put some knickers on. That is a joke, by the way, but she just jumped out of her skin. She was like, "What?" Replaced 5th edition, constitutional administrative law. So you've got to have a bit of humour in it, right? Let me just go and have a look and see where it said it. What was I actually doing? Constitution. Royal Commission on the Constitution is an important one. But I am going to show you something. What was it I wanted to show you? I just said what it was. I've forgotten where I was at now because I made a joke. What was it that Sir William Wade had said in his book? Come on, remind me. It was important. I'm trying to look it up. Spooky. Fur coat and no knickers. Yeah, she ain't got the fur coat yet. I'll see if I can find some rabbits. Sorry I'm late. Everyone out there. Evening, Spooky Bubba. Neil Russell. Hello, Spooky Bubba. How you doing? We've missed you. What you been doing? What you been up to? Come on, tell us. Don't run off. Doing a mum, well, and England's first UK, and he does neither. Yeah. Let's have a look. No knickers, DD. All right. No, it wasn't the no knickers. It was something else that I was talking about, and I was going to bring it up. What Sir William Wade said. What was I talking about in that book? You've thrown me completely now. I've got visions of Janet walking about no knickers, and it ain't doing me any favours with my mind concentrating on this show. Now, I've warned her before not to interfere with the show. Let me have a quick look. I'll find it in a couple of seconds. Index of names, no. Entrenchment, no. Oath of office, policy, politicisations, power, judges, judicial review, parliamentary commission. Someone's going to say something. Andy Burnham. Abuse of power. It's all in here. Bill of Rights, entrenchment, 30, 31 and 38, 40. I mean, Sir William Wade is excellent. Sadly, he passed away in the early 2000s. European Convention, Judges Function, Blacklisting, 69. Boundary Commission, Celtic Preference. Inequalities, Constitute Amendment of 44, Elective Dictatorship, Entrenchment Problem of 30, Judges. Function of 89, 93, 98, Judicial Adjustment in, Political Elements, Royal Commission, Criminal Injuries, Crown Privilege, Discretionary Power. Don't forget they're changing things in our Constitution they're not allowed to do. And he talks about an elective dictatorship here on numerous occasions, and so does William Pitt, the first Earl of Chatham, 1708 1778. Bill of Rights again is 31. Let me see if I can go and find this. Extra statutory concession gone. That's the Lord's. Entrenchment, function of judiciaries. I'm sure it was at 30. Travel, freedom to. So freedom to travel is an important one. Do you remember when I said, so 30 and 62. Let's go to 62 first, and then we'll go back to that. 62. Diocese passports. Do you remember when I said to you that our friend, let me have a look and see if I can get off of that. No, cancel. Remember when I said, because anyone... So what I'm going to do, hopefully, is bring this down. Let's see if I can pull that down a bit further. So, because I need you to be able to read this book. right? There it is there, right? So the right, passports, and the right to travel, yeah? There is another area where the term prerogative is loosely used and where, in addition, an infusion of law is badly needed. This is the matter of passports, or perhaps I should call it the citizen's right to travel. For many years, the government has claimed an unfettered discretion to grant, deny, or cancel a passport without reason given or fair procedure or right of appeal or legal remedy. And in the past, this supposed power has been used arbitrarily to restrict the rights of British subjects to leave the country, and also it seems to re-enter it. The Immigration Act 1971 made a minor change by providing that a patriot who has the right to leave and enter the realm freely must, on proper request, show a passport or other satisfactory evidence of his identity and nationality. But he may still be unable to enter other countries without a passport, and the denial of it may in practice deny him freedom of travel. In principle, it is highly objectionable that the executive should claim this power of administrative punishment, right? Now, just think about what they've just done to me. And what they're saying is, we want to see the bank statements of the English Constitution Party, the PayPal account, the bank account, and other information. And I was in particular asking about Bitcoin, right? And they wanted all that information. I said, that's a limited company. It's separate to me, right? So you can't have that information. Well, I didn't say you can't have that information. I asked them, what is it you're looking for? And they said, we want what we've just asked you for, and you need to give it to us, or we're going to cut off this, that, and the other, right? So just to make sure you get this, right? This is a similar thing, but to do with a passport. So William Wade is saying they don't have the right to do that, right? But there is no doubt that it does. A typical statement comes from the report of the Committee of the Privy Councillors on the recruitment of mercenaries in 1976, when there was concern over British mercenaries fighting in countries such as Angola, right? And by the way, I knew a few people fighting out there. The committee said, the issue of a passport is an exercise of the royal prerogative, and the document, when issued to its holder, nevertheless remains the property of the Crown. No United Kingdom citizen has a right to have a passport issued to him, and the Foreign Secretary, by whom the prerogative is exercised, can withhold or withdraw a passport at his discretion, right? They then quoted a parliamentary answer enumerating the type of person to whom it was the practice to refuse passports, one of which was, in very rare cases, a person whose past or proposed activities are so demonstrably undesirable that the grant or continued enjoyment of a passport facility would be contrary to the public interest. This is a polysyllabic way of describing anyone whose activities are disapproved of by the government. My first comment, which may not now come as a surprise, is that I question whether passports have anything to do with the royal prerogative in its proper sense. A passport, as such, has no status or legal effect at common law whatsoever. It is simply an administrative document. On its face, it is an imperious request from the Foreign Secretary that all whom it may concern shall allow the bearer to pass freely without let or hindrance, and shall afford him assistance and protection. In reality, it is an international identity card certifying that, and there's some important parts of this, certifying that the traveller is accepted by this country as one of its nationals. A United Kingdom national's passport does not have the slightest effect upon his legal rights, whatever they may be, to go abroad and return. Those rights are a matter of common and statute law, which the Crown has no power to alter. The Committee on Mercenaries very rightly said that the withholding or withdrawing of passports as a means of preventing United Kingdom citizens from leaving the country could not be justified either pragmatically or morally, and that what effect it might have would be based on bluff, right? Relying on the citizens' ignorance, right? This is such an important part, right? Don't forget, I sat there and read this out because just to make sure before I go on to this, right? So Tim sailed all around the world on a yacht without a passport. He said, I do not need a passport to travel. And when these different people come on board and had a go at him and all that, he said, I don't need a passport. Right? When I went on there, I did say to him, if you're going to a common law jurisdiction, that is correct. If you're leaving a common law jurisdiction and entering a common law jurisdiction, that is correct. If you go to an administrative country like France, and bear in mind, passports came from France, right? That's where they come from. It's part of Napoleonic law or Roman law. A passport is part of a Roman law system, right? Ignorance of the right at common law to leave the kingdom and return to it. Since it has no effect on legal rights, the grant or withdrawal of a passport is, now let me just get into this, possess the power to prevent. Cannot there represent exercise prerogative power. Formerly, the Crown did not possess the power. I've jumped a bit here, haven't I? Citizens' ignorance and the right of common law to leave the kingdom and return to it, since there has no effect on legal rights. The grant or withdrawal of a passport is not an exercise of legal power and cannot therefore represent the exercise of prerogative power. Formerly, the Crown did possess the power to prevent a subject from leaving the realm by issuing the writ of ne exia regno, which was once a favourite instrument preventing the clergy from resorting to Rome. That had legal effect and was therefore a true prerogative power, but it is now held to be obsolete except when granted by the court to a creditor against an absconding debtor. According to Blackstone, if I may invoke him again, by the common law, every man may go out of this realm for whatever cause he pleaseth, without obtaining the king's leave. Right? Passports do not enter into the legal picture at all. The important question is whether it is tolerable. Let me just make sure you can see all of this. The important question is whether it is tolerable that the government should wield an unfettered power to deny to a citizen the internationally accepted means of proof of his own identity and nationality. No reasons are given, and there is no right to be heard, since the whole matter is administrative and outside the law. In 1968, when the government had taken to withdrawing passports to United Kingdom citizens involved in a certain ways in Zimbabwe, they set up a committee to scrutinise and report upon these withdrawals. But it was only advisory and only concerned with Zimbabwe. Apart from that, there was no procedure or appeal of any kind, not even a right to complain to the Ombudsman. When also in 1968, and this is the important part, I want you to listen to what I'm saying now. When also in 1968, a journalist attempted to travel from London Airport without a passport as a test case, he was refused leave to embark. The authorities evidently knew he was a United Kingdom national who needed no such leave, but they refused to accept his evidence of nationality and treated him as an alien apparently without any good reason. This seems to have been a plain case of abuse of power, as well as a breach of the European Convention of Human Rights. But since no legal proceedings followed the test case, came to nothing. The right to leave without a passport is apparently now recognised, but that by itself is of little use if the government declines to provide the document to which it is required for entry into foreign countries. This is a murky administrative area where there is a crying need for clarification and legal right. It needs to be recognised, as an American Supreme Court has held, that freedom to travel is a constitutional liberty closely related to other basic liberties. It needs to be recognised. And then there's a load of other elements in this, and I can go on, but I just wanted to make sure, hopefully you're all still seeing this stuff. Brian, did you all enjoy that little readout? Right. The reason why this is important, and again, this is the Hamlin lectures, right? I don't mean to be disrespectful to other people. I know that sometimes I am, right? And when these people start talking to me about words of a spell, and I'm like, listen, go and abracadabra and fuck off someone else, will you? Right? Because you ain't going to abracadabra this country back to the way it was. You're not going to abracadabra terrorists leaving this country. You're either going to take back this country by claiming your rights and understanding what your rights are, by talking sense as a subject to the realm. These are your rights. You need to claim them, right? So that's why tonight I'm just talking about these various elements. Now, the difference between us, and I know there's people out there, and I don't mean any disrespect to Jason by saying this, there's some people who just don't like Americans, right? They refer to them as Yanks, right? Well, I've got to be honest with you, I don't particularly like Yankees. I'm honest. I'm being honest with you. I like a cowboy. I believe the southern states, all southern states, and that includes Florida. And again, if you go up further north, west, I think it is, Alaska, and then drop down through them western states, and the southern states of America, they have a completely different idea of their constitution. They absolutely know what's going on, right? And hopefully it's going to be pushed forward, right? But the beauty of these, the Americans, is they have kept the English way alive. They have kept the English common law alive. They have kept the common law alive. And in that law book there, it expressly states that the first 10 amendments of the American Constitution are in effect the Bill of Rights, right? And the Bill of Rights that was the law in 1791, I think it was. I said, wasn't it? Right. Let me just make sure I'm not going to be distracted for a sec while I adjust my sucker. Right. So there's loads of things that people need to obviously understand about it. But your constitution, and understanding the English constitution, understanding what your English constitution rights are, that's not difficult, people. Trust me, right? Let me just see if I can put it on here. And again, I don't do this. Lots of people have books behind them and all that, right? I've got books behind me. You can vouch for this. Oh, there are books all over this settee thing.
There's probably about 40 books on the settee.
There's about 40 books on there, right? So all these books I'll go through, right? Pass me that one there. That's it, that one there, because that's... Right, now, I want to show you another book. Now, I don't expect people to go and buy all these books, right? I've got a great interest in the law. I've got a great interest in England. I've got a great interest in our constitution and the rights of the people. I've got a great interest in the common law, the real common law of the land, right? So I'm going to show you another one, which is really important, and I'll give the person a shout out. there was a guy called Benicia, right? Oh, what is? Oh, blimey, that's so good. I thought it was a whole row of books, and it ain't. That's funny, right? So what I'm going to do now is raise this up and show you this book, right? And I'll bring it up here. Can you all see what that book's called? Right, the Ancient Laws of Cambria, containing the institutional triads and devoir, Mud, the Laws of Howell the Good, triadal commentaries, Code of Education, and hunting laws of Wales, to which are added the historical triads of Britain. Right, this book contains basically the common law of the land. And it also has got the Anglo-Saxon laws in it. So if I went back to a particular part of this, for example, I think there may be something I just looked at there and it's gone completely. Look. Right, there are parts of this book that did have tags in it. I'll read all through this. But this is the one that basically tells you. Let's see if I've got a tag in this one. There's one part of it, right? Because this is all of the law of the land. There are three foundations of the social state: privilege, possession, and law. There are three foundations of the law: protection, correction, and honour, as far as each operates to the advantage of the country and the tribe. There are three protections and securities of the social state: protection of life, the person, protection of possession and place of residence, and protection of natural right. There are three things which support the social state: affection, fear, and mutual profit. There are three things that strengthen the social state: effectual security, security to every man and his property, just correction where it is required, and mercy blended with justice where it is seen to be demanded from just time. Right, and then it goes in. There are three pillars of social sovereignty: the voice of the country, and judiciary. So it's telling you there the social state, sovereignty, the voice of the country, meaning the people, and the judiciary. Right, three things which ought to belong to each of these three pillars: equity, protection, defence to all, well-ordered regulations for the instruction, knowledge, and record of all citizens. There are three things which strengthen the social state: power, protection, and correction according to the law of nature. And then it goes through, and there's some further bits in here, but I wanted to show it to you. This is the. I knew this was. There's a bit of paper stuck in there. I knew it was stuck. When did that get stuck in there? What's the date on that? Verified by PIN. Did it tell me when that date was? I don't know, but it was a long time ago. It's all faded, right? So I'm going to have a look at that in a second. So what I'm going to do now is show you this part. Now this is the triads, right? I'm just going to make sure that you understand this, right? 15. There are three primary obligations of sovereignty: to maintain a splendid independent establishment. This is this one I'm reading. To encourage the diffusion of the country's sciences so that they may be mutually supported by vote and law, and by the country and the sovereignty, and to maintain the protection of patriots and the tribe and of citizenship, with the protection due to foreigners who are under the protection of citizenship. There are three oppressions of sovereignty: injustice, which denotes the want of protection and to patriots and their property; violence, such as theft, murder, ambuscade, and powerful tyrannical exactions in opposition to the country and the law; and carelessness, such as want of consideration respecting the fortunes of the times; their consequences and demands where they operate to the injury of law, and these evils can only be guarded against by the voice of the country and the sovereignty, which must investigate, examine, correct, improve, and modify them as existing circumstances may require. There are three primary excellencies of sovereignty: protection of patriots, the correction and prevention of evil, and the guarding against ignorance in any cause, so that a just judgment may be given. Right, and then it goes in, and there's more to this, but I just want to make sure. that the king decides shall be inflicted. Now, what I'm going to do is take you to another part of this. There's loads of bits of this. Don't forget, I read this a long time ago, but I just want to show you this part. You may not be able to see this. There are three powerful reasons that prevent the judge and the court from inflicting capital punishment upon offenders. A mother accused of crime in protecting her children, a youth underage, and a stranger with a barbarous language who may transgress against the law and citizenship. There are three excuses in law for remitting capital punishment: inability, ignorance, and extreme. Right? This is the only thing they're allowed to do. Want, for these things, prevent infliction of capital punishment and deliver offenders. Right? And then if you go back over here, there are three things which disorganise a country: a neighbouring country, very oppressive privileges, unjust decision in law, and reprehensible negligence, permitting the regulations of the country and the tribe to be destroyed. Right? That, what they're saying is that is unlawful. Right? Now, when you understand, right, that comes from the old laws, the oldest and most ancient laws in the country. Right? These laws date back thousands of years, right? Or hundreds and hundreds of years, right? Let me just make sure. I am going back to the bio. Hello, I'm back. So the purpose of this is, really and truthfully, we've got to start seriously getting this message out. We need the seminars going at least monthly, maybe bi-weekly, so every 2 weeks, right? But again, we need people out there, and we're trying to find people who actually do want to understand what's going on, that they're looking at what we're doing and saying these people are actually telling you what the law is. Now, in them law books, it tells you that the Jesuits were the people that were attacking England, right? It tells you in that Halsbury Laws of England. And when I read these things, and I say, so I'm talking about the Jesuits to people. People are suggesting, that was a long time ago. It's nothing to do with now. And yet you have Jesuits, and you have a Jesuit order, and you have, and again, it was such a bad order that Roman Catholics actually forbid them at one stage, and said you cannot. They actually took down the order, and then they reinstated it, and that's where the problem started again. Right, so everyone keeps blaming the Jews. Right, I'm not saying that the Jewish mafia don't exist. I'm not saying that the Jewish mafia are not seriously a problem in this country. They are, and they always have been. Right, but what I'm saying is there's another group of people that work closely with the Jewish mafia, and that's the Jesuits. Right, the Jesuits are not normal Roman Catholics. Normal Roman Catholics are just like me and you. Normal Jews are just like me and you. Right. But they are the people that have orchestrated this, and then you have the jihadists. So I describe that as the three J's, right? The three J's. And in order of importance today, it's the Jesuits, the Jewish mafia, and the jihadists, and they are all aiming to attack us now today. And the English need to stand up against all three, right? Tell them to stop and say, listen, we are going to take back this country. But the people really do need to understand. You can't just sit there and do nothing. Right, let's have a look at that. So let's see which this one says. No, not that one. That one. Rebecca. In a way, the liberalism of the 60s sped up the Fabians' final goal. I think what really caused the problem with the Fabians was we lost the Second World War, right? So whilst I am not a fascist, I want everyone to understand that I'm an Englishman. An Englishman only thinks of the Constitution of England and the common law of England and the protections that our constitution, and that means the separation of powers, that means the limitation of Parliament on what it can act in law, the limitation of the Crown in what it can do, and the limitation also of the judiciary in what it can do, right? So there's three separations of power. That is the Constitution of England. Fascism and communism are authoritarian. They believe in a Roman law type jurisdiction, the same as Scotland and France, right? Now, the reason why America has been absolutely off to a tee with this, but people need to understand that in 1948, Clement Attlee, a Fabian, passed a law. They actually passed two laws, right? Or actually three laws in 1948. That's when I can see via reverse engineering, and bearing in mind I am a system engineer, right? So I look at things and I can see you don't need to be a computer engineer. System engineer looks at manual systems, computer systems, any type of system, and will tell you why it's going wrong and how to fix it, and how to fix it in such a way that it doesn't break again, right? I just want everyone to understand that. System engineering is about looking at a system and saying, how can I fix this, right? You're solving problems. That's what your job is as an engineer, right? And there be complex engineering and there's not so complex engineering, right? So importantly, the Fabian government in 1948 passed a law through Parliament, one that top and tailed Section 2 of the English Bill of Rights, which it was not allowed to do, that in effect made Parliament sovereign, because it then enabled them to tell people this is what the law said, because they didn't show the people the top bit and the bottom bit of that paragraph. They only showed them the bit that they left, and they did it by stealth. They'd done the same thing in 1858, right, with the whole of Section 3 of the English Bill of Rights, which clearly states 3 times forever, and it says and clearly states in this realm for all time to come once. So 4 times it references forever. People need to understand that once any statute says that in English law, it is forever. You can add to it, you can't take away from it, and you can't create tyranny, which is what they're doing, by ignoring it. So again, I just want to make sure everyone understands. When I start talking about the law, and again, I'll pull this one off and we'll see our massive little hole in the back, right? When I start talking about the law, this is not a green screen, right? This is Halsbury Statutes, 4th edition, volume 10. And again, I'm going to put it up on the screen so you can see that. Constitutional law, right? It's not a Mickey Mouse book. If I went through this and started to tell you exactly what our Constitution says, you would be sitting there saying, so Graham, why is it they're not taking any notice? Well, the answer is, for them to take notice, you have to understand what your rights are. Because they've taken it out of the curriculum, they've taken it out of the bar exams, the barristers don't know. If a barrister don't know who's been trained in law, then judges don't know, because it's the barristers that become King's Counsel who become judges. So if none of them have been given that training, a bit like a doctor, right? If a doctor hasn't been trained in nutrition, how can that doctor advise you that you need potassium? So the natural and best way of doing that, rather than using pharmaceutical supplements, is eat some bananas, right? How can a doctor say that to you if he hasn't been told it, right? Or he hasn't been trained with that? And nutrition is a degree in itself, and they don't class it as a medical degree, but they should do, right? But they don't do it. So again, just to make sure you're all aware, because I need to put this up there. And by the way, I need new hearing aids. I want everyone to understand what this book is, right? So I'm going to keep showing you the books so you understand and you can put these parts out there. Select statutes, cases, and documents that illustrate the English constitutional history, right? Now, when you go to the Bill of Rights, right, you can it'll actually tell you exactly. And let me see if I can pull it off. No rude comments, please. Don't stop giggling. I don't know. What do you think of people? My gnome is sitting there. All I mentioned was I'm trying to pull it off. What I meant was the page and pull it off. I don't know what she thinks I'm saying. It's disgusting, isn't it? Do you think? It's a bit weird, isn't it? I'm going to tell her off later. So I'm going to go back to my main screen again. And I'm really grateful for the wonderful person who advised me to get one of these because it is helpful. I just need a bigger desk and a better form. And really, I need a better way of pulling this up. Let's see if I can bring that up so everyone can see it, right? So you all understand from that book, there it is there, the Bill of Rights, William and Mary, Session 2, right? An act, this is crucially important. I tell everyone this, and everyone needs to understand exactly what I'm saying, right? The short title is what I'm showing you on the screen now, the Bill of Rights, right? The long title it tells you what it's doing. An act declaring the rights and liberties of the subject and settling the succession of the throne. Why was it important? Because this comes from the Declaration of Rights. The Declaration of Rights was the original contract, and everything goes back to that. Everything that we are currently doing in this nation goes back to the Declaration because it was the original contract, right? Please, please, please remember that, because the only reason that King Charles III is the king of this country is because he swore, as his ancestors did, to keep to this contract, and he has not done that, right? So there, whereas the Lord Spiritual Temporal Commons assembled at Westminster, lawfully, fully, and freely representing all the estates of the people of this realm, did upon the 13th day of February in the year of our Lord 1688 present unto the Majesties, then called and known by the names of style, William and Mary, Prince and Princess of Orange, being present in their proper persons, a certain declaration and writing made by the said Lords and Commons in the words following this, right? And again, remember what they said. Whereas the late King James II, by the assistance of diverse evil counsellors, judges, and ministers employed by him, did endeavour to subvert and extirpate the Protestant religion and the laws and liberties of this kingdom, by assuming and exercising a power of dispensing with and suspending of the laws and the execution of laws without consent of Parliament, right? And just to make sure I am clear on this, I am going to take you to the major sections. Again, all of this is in there, but I want to, and again, these are markings in this book, not from me. But from the person who originally read this in 1903 or 1905 or whenever they read it. So I'm going to show you this part because it's important, right? Really important that people get this. Let me see if I can just bring that up on the screen. Hopefully you can still all see that, right? So hopefully it will come into focus, right? Now, those markings on that page are not my markings. They are markings by the person who read this 100 years ago, right? Or whenever he read it, right? But this is chapter 2. There's many other chapters to this. And this is the fully codified Constitution of England in terms of the Bill of Rights, right? They are not allowed to take this away. But chapter 2 is important, right? Because, and it be further declared and enacted by the authority aforesaid, that from and after this present session of Parliament, right, which was for 1 year, no dispensation by non-obstante of or to any statute or any part thereof shall be allowed, right? So you're not allowed to back on. Hopefully I'm back again. You can see me. And I'm going to go back to that. Just so everyone's clear on it, I'm going to go back to that. Can you all see me again now? It just switched off. So I've got a number of cameras operating on the same thing, and everyone sees it, right? Come back, DD. I'm back, right? Let me just make sure. What's the time? 9:30, right? So we ain't going to go on for much longer, but hopefully you can see this. But chapter 2 is really important because they top and tailed it unlawfully. The Parliament was not allowed to do it. Clement Attlee did that and authorised it to be done, and they buried it in legislation so people didn't know what they'd done. And they took out upon the top part and the bottom part, and they made it appear that Parliament was allowed to change the Bill of Rights and change certain parts of our Constitution, which it was not allowed to do, right? So they acted unlawfully. Constitution, it was unlawfully. So I'm going to read out the whole chapter again. And be it further declared and enacted by the authority aforesaid that from and after this present session of Parliament, no dispensation by non-obstante or to any statute or any part thereof shall be allowed, but the same shall be held void and of no effect, except a dispensation to be allowed of in such statute and except in such cases as shall be specially provided for by one or more bill or bills to be passed during this present session of Parliament. Do you all understand what that means? You cannot touch the English Bill of Rights, right? But they did, and they did it by stealth, and it was the Fabian Society that did that, right? You should all be up in arms because Daddy Dragon, Graham Moore, right, the English Constitution Society, the English Constitution Party is telling you that these people have defrauded the people and that Crown allowed it to happen. But did the Crown know? I don't believe they did, right? Because it was done in a fraudulent way where they buried the element of this, and I'll show it on another document exactly how they did it, right? Now, just to make sure you've all got this, here is the other element which they took away, right? And again, I'm going to bring it up, you can see it, right? This was the section 3 that they removed in 1857, right? And there's certain things that happened that they shouldn't have done. And I'm going to say something else, and I want everyone to understand what I'm talking about, right? Right, this part completely removed, right? And again, if you can see the reference to Hallam there, right, and Anson there, right, I want everyone to understand Macaulay H.E., Hallam and Anson, right? So making sure you understand that. Here is the book. I'll have to show you in a couple of seconds, but I'll show you this one. Right. Well, I'll show you that when I go back to the screen. Right. So all I want is for people to understand that nothing that I talk about is bullshit. What I'm actually doing is directing you exactly to the Constitution, how they've lied to us. Right. But this says, provided that no charter or grant or pardon granted before the 300th day, 20th day of October in the year of our Lord 1689 shall be in any ways impeached or invalidated by the Act, but that the same shall be and remain of the same force and effect in law, and no other than if this act had not been made. What did that do? It protected the Magna Carta, it protected the Charter of Liberties, it protected the Charter of the Forest, it protected all of these pre-existing rights that we had, and all of the rights that are in the Bill of Rights, well, actually half of them that are in the Bill of Rights were pre-existing rights, and half of them were new rights because there was tyranny, right? But I want everyone to understand what I've just said. Now, I'm going to go back to our main screen because I need to show you a couple of other bits. And I'll go back to my briar. There's something flying about in here, and it shouldn't be, right? I just want you to understand this, right? So that is that book, right? And again, it's an old book, well read, I may add, right? It mentioned that book. There's 3 of these. That is Law and Custom of the Constitution, Anson. I've got all them books. I don't just read, and again, I've got books on there, original books by A.V. Dyson, right? And again, when they talk about Hallam, they're talking about these, right? So they're coming off of my shelf. I've got other books over there, same books, they're the ones I read, right? In there, you can see that there's elements in that. And what I do is I go to the pages that I'm told to go to read up, and then I start looking at it. And in here, it starts talking about constitutional history of England, the Lords, and it tells you everything that they're saying. Which one? This one is about our absolute right to vote and the fact that they can't do anything with it, which is that one there, right? And these books, when I refer to it and then refer to Dicey, etc., that one's getting a bit of a split down the end of it, right? So none of this is a green screen. It's all real law. That massive, great big one there was given to me by EP70, which is the original Halsby's Laws of England. There's a number of them volumes. I'm still trying to find the rest of them. That one there, like I said, is the other guy that I spoke about. And then you go into our oath system. Now, why am I mentioning the oath system now as we close the show? Because I'm going to ask you all a question. Right? And this is a serious question. If Judaism is, as they describe, part of Christianity, and Christianity is part of Judaism, why is it that the Jews of this nation of England would not swear a Christian oath in Parliament, or a Christian oath as a part of the judiciary, or a Christian oath of any other nature? And why was it that Queen Victoria passed a law called the Jews Relief Act and the Oath Act that changed the oath system, that allowed Jewish people to be elected to Parliament? And the first person who was elected to Parliament after they changed that and allowed Jews to take a different oath, right? Which is when the first change of the English Bill of Rights happened. So the question to the audience is, if Judeo-Christians, as they describe it, is no different to Christianity, and we're all singing off the same hymn sheet, as it were, yeah? Why is it the Jews would not swear a Christian oath? Why is it that they would not speak of Jesus Christ? Why is it that they wanted that oath system changed? And prior to that system, most of our constitution remained intact. Why is it after that period it was systematically destroyed? That is the question to my audience. And I think we just got an answer there. It is because Christianity accepts the OT, but Jews do not accept the NT. You'll have to make that more clear. Have you got an idea what that means?
OT and NT.
Yeah. And the person who's given me that is highly religious, trusted member of us lot. So I'm going to wait and see if I see his answers come up again. Because Christianity accepts the OT. I think that, but Jews do not. Right, let's have a look and see if he's put it up again. Ramsey McDonald, because Christians forbade usury. That's a good answer. Christians do forbid usury. Simon, because Jews haven't got the same beliefs as Christianity, as the Jews got Jesus Christ to the cross. Let me have a look and see what that says. Oh, hang on a minute. So Old Testament and New Testament. Oh, right. So now I can go back to that. Sorry, reading and thinking while I'm trying to look at this is a bit more difficult. Right, now it makes more sense. So I'll put that back on the screen, because the Christianity accepts the Old Testament, but the Jews do not accept the New Testament. Okay. As far as I know, the oath system, or unless you're saying that in the oath system you had to swear on the Bible and it was the New Testament and they wouldn't accept it. But that is very similar, if the Jews are doing that, to Islam, where they accept no changes to the Quran whatsoever, even if the Quran is heinous in what it says, like hacking at people's necks and chopping one arm off and one foot off. But although I haven't got a problem with did everyone know that there was a massive Jewish conspiracy after the Second World War to poison 6 million Germans? Did everyone know that? This is true, by the way, because I see it on Twitter, and I said, well, maybe we should bring some of King Henry VIII's law about how you deal with poisoning, and I put it on Twitter. To Grok, how did King Henry VIII deal with poisoners? And he come back and he said they boiled them to death. There was a few people who agreed. To a Jew, the Old Testament, now I understand what that means. The Jew is the Old Testament is their constitutional document religiously. Okay. I don't know what word Allah is bullshit. Spooky Bubba, you got away with words. Let me hit that one now. Strychnine in the food and water. I think it was arsenic. Never actually removed from the Bible because it was never part of the standard biblical canon for mainstream Jewish or Western Christian traditions. And let me just make sure I'm clear on this. Canon law is Roman law. Canon law comes from Roman Catholics, and that is, and I've got a whole document from the Selden Society that describes it's completely incompatible with the common law jurisdiction of England. Just to make sure everyone's aware of that. Graham still flying the flag, mate, after the visit through a cousin. Graham still flying the flag. Dan, Archer not. Hi, Maria. Ace Jace, hello. Let me have a look. Let's get the likes up. Graham is a national treasure. Thank you very much for that. I consider myself as just a normal, everyday person. There is nothing special about me. What I believe in is England. What I believe in is you. And what I believe in is the education of our constitutional rights and common law rights to the people of England, and especially the indigenous people, right? There are some things coming up that at some stage in the very near future, which might be why they've decided to start attacking more than... I think more and more people are talking about the Constitution. Let me just show you this again, because I think it's really important that people see this. Right, hopefully it's on your screen as we speak. Let me take my camera off. Right, let me take that camera off. Disable camera. You should be able to see the whole thing on your screen. William Pitt. Let's see if I can bring that up. And bring it over. Blimey, it's gone a bit pear-shaped on me, isn't it? William Pitt, first Earl of Chatham, 1708 to 1778. Instead, let's see if I can get the whole thing on the whole quote on the screen. You've got that. Instead of the arbitrary power of the king, we must submit to the arbitrary power of the House of Commons. If this be true, what benefit do we derive from this exchange? Tyranny, my lords, is detestable in every shape, but none so formidable as where it is assumed and exercised by a number of tyrants. But my lords, this is not the fact. This is not the Constitution. We have a law of Parliament. We have a statute book, and I've just shown you some of that, and the Bill of Rights, and I've just shown you that, right? Who are the tyrannous people? Who are the communists? Who are the people attacking the English currently? It is, without any doubt, the Fabian Society. They've been doing it a long time, at least from the mid-1800s. I can show you every element of what they've done, and they've done it by stealth. We need, as a group of people, to understand that, to promote the fact that there is the Constitution of England. It's an extremely good common law jurisdiction. It is 100% codified in many of its parts, and some of it is what's known as common law. But people need to understand the Constitution is the solution. And with that, my friends, I am now going to, let me see if I can pull that off. Is me, just as a judge. I'm going to say good night, God bless. I have got to still do a lot of writing and write-ups, and we're going to carry on doing what we can do. But I will see you all tomorrow night, same time, 8 p.m. I will try to be early, and we'll go through from that book the actual Bill of Rights, the real Bill of Rights, the Bill of Rights as it originally existed. And there's no arguments about it. It's come from a proper law book. It's an old law book, and you will see that you are being deceived. That's it. Thank you. Good night, and God bless.